So it's now past 9:30. So good morning. We're going to get started with our opening remarks. So good morning. During the declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted by electronic means through WebEx, an online digital platform, and streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. This will be a virtual public hearing, and participants who have registered in advance will be able to make their presentations to the committee using WebEx, an online event that is being moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting either by their computer, a phone or tablet app, or by telephone. All participants will automatically be muted on entry, and when your item is called, each participant will be unmuted by the moderator, one person at a time. Only the committee members will be participating by video. There are 3 of us present in the Etobicoke Civic Centre Council Chamber. Myself, Michael Clark, Chair. On my left, Neil Palmer. On my right, Stan Kumaric, and by virtually, Laura Alderson. Land acknowledgements. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is now called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that applies to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. Anyone who wishes to receive a copy of the decision of the committee on an application here today must submit a written request for a decision by email. Please ensure that you include your name, your address, and email address, because Committee of Adjustment and the TLAB will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, decisions may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances to the Local Planning Appeal Tribunal, LPAT. Appeal instructions are set out at the bottom of the decision of the committee. In the virtual setting, we'll call each order in the item listed in the agenda. We do not vet the agenda. We'll be just start at item number 1 and plow through. There are 12 items on this morning's agenda. In making your submissions, where an application is uncontested, the agent or applicant will proceed with the presentation only if required, and the committee may ask questions and take the matter into the committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and Mr. Kumaric, who's watching the clock, will comment when you're reaching the 5-minute mark. And at that point, we just ask you to sum up. When addressing the committee, please clearly start off by stating your name and address, and please remember to confine your remarks to the matters outlined in the application. We deal with planning matters. We don't deal with construction issues or personal disputes between neighbors. The applicant or agent goes first and makes a presentation to the committee of the application. Again, if required, usually where an application has other people registered to speak, we will ask for that presentation. Please note that the committee may not entertain revisions to our proposals at the hearing today. The committee may decide in such circumstances to either defer the application if it's substantially revised in order to ensure that the revised application is accurate and that all those entitled to notice of the application are informed of the changes. After the applicant has spoken, then individuals either in support or usually opposed to the application will be invited to speak. Committee members may ask questions of each speaker after they finish their presentation. And when all speakers are finished, the applicant or agent has an opportunity to rebut only those issues that were raised by the speakers, to answer any questions or respond to the concerns raised, but not to introduce new information at that point. That will then mark the end of the discussion. The application is then taken into committee for a decision and perhaps some final follow-up questions. Before we start, we have some housekeeping matters to take care of. Do we have the minutes of the last meeting? I believe 2 meetings to approve, or just 1?
Just August 13th.
Just the August 13th. Okay, so the August 13th minutes. Can I have a motion to approve those minutes?
I'll move for approval.
Thank you, Mr. Palmer. Seconder for that, Ms. Alderson. All in favor? The minutes are approved. Any declarations of interest of panel or staff on the items in the morning agenda? No. And Madam Secretary Treasurer, are there any files to close? I believe there is.
We do, but can we deal with those later because I haven't been provided with any information on them, so I just want to follow up.
Okay, that's fine. Okay. So in that case, I guess we can get started with our first application. Item number 1, 2095 Codlin Crescent. We will deal with deferral requests as they arise as we go through. We're not going to deal with that at this point, but we'll deal with them as we go through the agenda items one by one. So item number 1, 2095 Codlin Crescent. This is an application to permit the existing use of outdoor storage, truck and trailer parking, and a previous committee of adjustment decision approved the use of the outdoor storage parking for a 1-year term which expired May 31st, 2020. So they're looking to extend that. We have on this application planning recommending refusal. We have support. Oh, it says our notice says that we have a letter of support from a neighbor, but I believe the letter, in fact, is a letter of opposition from the Eye Center at 2100 Codlin Crescent. That's all we have. We have transportation. Planning, as I said, is recommending refusal of the application, and transportation has no comment on the application. And we have registered as speakers on this application. The applicant, Paul Cronus, and one member of the public, looks like a neighbor at 1791 Albion, or is that are they on the same side, or is that someone with concerns?
I'm not sure. I think it's someone with concerns.
Okay, so they're both on the line, and we have, I guess, the first is Mr. Cronus, the agent. Good morning, sir.
Good morning, Mr. Chairman and members of the committee. Yes, my name is Paul Cronus. I'm a senior land use planner at the offices of Weir Folds. We're solicitors for the owners, Streetsville Road Services. You are correct in identifying that this matter was before you last year, upon which approval was granted for a 1-year term to allow the existing tenant, who we and the city all understand would like to see relocated. I just want to run through a very quick chronology of what's happened and why we're in this situation we are today. We are seeking approval for 1 year, but to be fair, because of the events that have taken place, a lesser time would be appropriate, and I will give you some reasons why. When we got approval last year for 1 year is to put us into an interim or a temporary zoning compliance situation to allow the existing tenant to relocate. Unfortunately, as I indicated in last year's hearing, there are very, very few sites that are available for a use like this. And despite all the hard efforts that the tenant has engaged, he hasn't been able to find anything, and that continues to be the case. However, we, like the city, and as you will hear from the neighbor, want to see this area improve. There's initiatives which you dealt with at 2045 Codland Avenue. They allowed the severance for a gas bar and a hotel redevelopment, and we embrace that. We see value in that to our property and value to the village of Clairville, and we embrace that, and we embrace the planning vision. The city staff planning report is consistent with their initial one. They have a vision that they want to implement immediately, but however, development doesn't happen overnight. It takes time. The owner at 2095 is in the final stages of site plan approval, and that's going to take 6 to 8 months before there's a shovel in the ground at least. As soon as we got approval last year, the client engaged myself and experts to prepare a site plan and file it with the city. We started that process around October, November, within 5-6 months of the approval that your committee graciously granted. We had a pre-consultation meeting with the city in February 2020, as you noted in the report, and we indicated at that time that we will be filing an application to continue the use for 1 year to allow that development application process to proceed. However, then we had this thing called COVID that hit, and everything shut down. We lost a lot of time. The tenant was not able to find any resources to relocate his facilities, and so the owner decided in May of 2020 that the best thing for them, because they're not developers, they're street pavers, that they're going to sell the property, and they've listed, and it's currently listed for sale. They've had 3 offers that came in June and in July. They accepted one of the offers, and the then purchasers attended the city. They did the due diligence, and they did not find the zoning answers that they were seeking, so they did not waive it and abandoned the agreement of purchase and sale, and that happened around August. Now, it was just by then where the city started re-engaging with these virtual hearings. I must commend staff and yourselves for embracing this new technology. It might be here to stay, we don't know, but it certainly helped to move applications along. The property is still listed. 2 offers are expected to come in after the long weekend. So we will be eventually selling the site, and the tenant has been told with no uncertain terms that they will leave because we have to offer vacant possession. So what we're doing is not a permanent zoning change. It's an interim to allow continued compliance. We don't want to engage with the city in litigating whether the use should or shouldn't be there. We know it should not be there. And we embrace that vision. And in fact, our highest and best use is not what you see today. So I was going to recommend, subject to your approval, to continue to have interim zoning compliance. I was going to recommend that we've had the benefit about 4 months now of this extension until we had the hearing, and we don't want to extend it 1 year from today. I would like to recommend that you, subject to your approval, provide a condition that says the decision will expire the earlier of 8 months from the date of your decision today, or within 2 months from the date the property is sold. So that way we can then ensure that the property is vacant when we sell it over, when we hand it over to the and that you know, in all fairness, and you'll hear from the neighbor how he's not being able to do certain things. I've read the letter and I understand what he says. I have to do some planning, investigative work to find out who the gentleman is, because he didn't sign the letter and there was no telephone number. But I did connect with him yesterday. We did explore it. He's adamant he doesn't support it, and I appreciate that.
Yeah,
And I know
Mr. Cronus, if you can wrap up, you're over 5 minutes, please.
Okay, thank you.
Thanks.
So, you know, we read the planning comments, we read the transportation comments, I read the objection, but under the conditions, a temporary approval, we feel meets all the 4 tests. And I welcome any questions that I can answer, and I'll respond when I hear the gentleman's concerns.
Okay, so I just have a question before I put it over to the other members. Like, it looks like back last year, planning was opposed even at that point. You got the 1 year period in order to be able to do this. The planning report, you know, talks about the unkempt position. You know, I don't know if they're specifically talking about your client's property, but that there's refuse and tires, and it's not just for parking of trailers, but the area seems to be in pretty bad shape. I don't know if that's specifically, it says in the middle, numerous violations issued. I don't know if, oh, it says dating back to May 2010. For outside storage of derelict vehicles, derelict equipment, shipping containers, renovation waste, loose tires, etc. So is that continuing on the property to your knowledge, or is it just now, you know, those date back, you know, 10 years? So
They do, sir. They date back some 10 years ago. We purchased a property in 2016, or at least the client did, and they obviously cleaned it up. They have good communication with the tenant. There are other users in the area that have a similar facilities, and you'll hear that it's all blended for the purposes of the eye. You know, you can't trace where things are coming from,
right.
and I'll speak to that when I have to. But yes, the site has been cleared. But again, you know, it's not a use that is embraced by zoning, not a use that we embrace, but we're trying to make sure we're not antagonistic with the city in terms of zoning compliance. And that's why it's important for us to have this interim approval.
Okay, and I guess your status with the tenant is you have a lease that permits you to have them leave in 8 months, or within 2 months of a sale, they're month to
It's
month?
month to
Or-
month, sir. Month to month. It's month to month.
Okay.
Yeah.
Okay, let's see if anyone else has any questions, and then we'll hear from the neighbor. And we also, I believe this neighbor is different than the neighbor that wrote the letter. So we do also have the letter of opposition. Okay, anyone have any questions? Okay, for sure. Yep. Of course, and Mr. Cronus will have a chance to respond in any event. Okay, so let's hear from Mr. Chowdhury.
Yes, my name is Surendra Chaudhary. I'm the owner of 2100 Corlin Crescent. Under the name, the company is registered at Sura Ventures.
Okay, so you're the author of the letter that we have that I just referred to?
Sorry?
You're the one who wrote the letter to us?
Yes.
Surav Ventures.
Sura Ventures.
Okay, I just want to know if we had two people or if you were the same person that wrote the letter. So you're the same person who wrote the letter that we have before
Yes.
us
Yes, sir.
with the Art Eye Care Center.
Right,
Yeah.
right.
Okay, go ahead, sir. Tell us what your concerns
Okay.
are.
The problem is there, last year I was there and I put an objection through, and the committee said that they were going to go for 6 months, and the lawyer for the other party was again pushing to go for 1 year. And like then in here now, they have no intention of moving. The city can go and check the thing in there. There are tires there. There's a shit all over there, basically. My apologies for the language. And the way these people have done it, they have no intention of going anywhere. 2 weeks ago, they even started putting a new fence in there so that, you know what, they think that they are going to be there. In our case, both sides of the street, they train their driver, they park their trucks, and it says right there, no parking, no standing, no nothing. And I have the pictures to prove it. And in our parking lot, their cars are parked, and in our driveway in the back for the dogs, they are practicing their driving skills. And the garbage is all over on our grass. And I mean, we cannot have a decent operation of any kind in that area or in that building. When I bought this building in 2012, this building was approved for a medical building and for office or whatever. Now, at this moment, I'm stuck with these people to deal with it on a daily basis who has no intention. If you go and see that one, this has basically it's an environmental disaster. There's an oil all over. And there are people like, I don't know what kind of people they are being trained for any reason in there. I'm sorry. I mean, I'm frustrated. I cannot invest $15 to $20 million to go and even get this improvement, get your permission to get further and do anything in that building, other than warehousing at this moment. I'm really frustrated.
Okay,
I need help
yep.
with the community.
Thank you, Mr. Chaudhary. Anything you'd like to add? I don't know if I cut you off or you're finished what you had to say. So you would like us to refuse it on the basis that it was approved last year for to expire May, and that the status quo remains.
Yes.
Okay. Committee members, any questions for Mr. Chaudhary before we go back to Mr. Cronus for his rebuttal? Or can we? Okay. Mr. Cronus.
Yes. Yes, thank you, Mr. Chairman, members of the committee, and thank you, Mr. Chaudhry, for your comments. These were consistent with what I heard yesterday. I'm going to start a little bit backwards in terms of environmental disaster. I think it's an unfortunate use of terms because we take great pride in our property, especially if you want to sell it. That's the last thing we want. There is no outstanding property standards order on this for all the stuff. It's also unfortunate that Mr. Chaudhry fails to distinguish between properties. He talks about a fence that went up, and I personally went yesterday to investigate this, and I can tell him unconditionally in the committee that fence is on the neighboring property. It's not on our property. We have done no improvements of that nature proposed. The driver training that he's speaking about is on the neighboring property. It sits higher than us. They do park all over the street and they do the training on this property, but it's not from us. The trucks that I use this property, they're not from us. The ones that park on Alcide, they're not from us. We have a very good rapport with our neighbors. The use next to us is causing the concerns that Mr. Chaudhry's complaining about, and there's a similar container service just down the road as well. I remind you, there are no transportation issues that were explored by the city. I also want to say that if we wanted to make this thing permanent, it would not be through the Committee of Adjustment. This is not the vehicle to make permanent use of the nature. It would have been through a rezoning. And that's a sign that we are sincere in our intentions to move on. The tires and all that, again, it's not from us. Unfortunately, because Mr. Chaudhry is so charged with his views, anything that is adverse to his interests, he expresses in this forum because we're the only ones in this whole area that come by and ask for your approval, not anyone else. And there are others in the area that probably Mr. Chaudhry should explore as well. So, having said that, I think the interim request for an interim zoning compliance is prudent. And Mr. Chaudhry, when he wants to do his eye clinic, by the time he gets his permits again, it's 6 to 8 months out, we will be out of the site.
Okay, Mr. Cronus, one question. So you said that your use is outdoor parking of trailers and trucks, and what are the adjacent uses? You're saying the problems are arising from the adjacent.
They're similar. They're similar, sir. They're similar use. I don't know how they got there. It's something for the city of Mr. Chaudhry to explore. They have a driver's training facility. You can see the trucks on their site that clearly say driver training. They installed the fence so they can screen it from the street. They park on Alcide. I personally investigated this yesterday when Mr. Chaudhry complained to me. I went out after our call around 6 o'clock, and I did the visual because I wanted to satisfy myself that yes, there were those concerns, but no, they're not from our site. So that's all I can add to that discussion, sir.
Okay, thank you. Any further questions for the agent or for the concerned neighbor?
Yeah, I've got a question. Mr. Cronus, just wondering, so you had a site plan application, and I assume that's been abandoned because the property is now for sale. Is that correct?
Not quite, sir. We had a site plan application that we pursued through a pre-consultation with the city to say, here's what we're thinking of doing with the site. Then they give you a set of comments, and then they say, go ahead and bring us a complete application that involves the bringing together of different experts and different reports. That pre-consultation meeting happened in February 2020. That's just about 2 weeks before COVID hit. And then everything got shut down. And instead of pursuing that redevelopment aspirations, the clients concluded that we're not developers. We'd rather sell the property, and they listed for sale in May of 2020. Okay. So they've abandoned their aspirations for development. They're going to find another location for their paving operation, and it's not in this location.
Okay, so the site plan application really has nothing to do with your client's current use. Is that correct?
Correct, sir. What we did is we filed an application that showed the redevelopment of the property with various permitted uses on the site. Not open storage, nothing to do with the storage facility for the equipment related to paving. It had to do with buildings and uses that were consistent with the underlying zoning bylaw that would meet the vision of the city.
Okay, so
And that's what we were pursuing.
really, your client really has no incentive to find another site if we give them an extension.
Well, no, the extension is only to allow interim compliance, to permit the sale of the property, and upon expiration, they're going to be gone. They're going to probably be gone earlier because, frankly, there is a lot of interest in this property, given what's happening next door, stuff that you just approved the latter part of 2019, and it's not going to remain as as what you see today, a truck terminal storage facility. It's going to be different. You know, we have 4 acres of property, 4 acres. There's no need to burden the public streets. There's a lot of room, and it's a big site that will accommodate a very compelling development site for someone, and just not us. We bought it for the purposes of putting up a building for the paving operation, but we realized that's not the location to be. And we're not developers, hence the sale of the site.
Okay, so your client, I'm confused as to who your client is, whether it's the owner or the logistic use.
No, the owner,
Okay.
the owner.
So it's really, his operation is conditional on whether we extend this permission or not, I guess. So if we say, no, we're not going to approve this, and he's got to be out of there September 1st, I guess.
Well,
Well,
on a practical basis, not to give Mr. Cronus and his client any ideas, but all they got to do is appeal to LPAT, and I don't know how long LPAT is taking to have hearings.
TLAB.
TLAP, sorry, my mistake, TLAP.
Correct.
So I don't know how long that would give him an extension. All he has to do is appeal, and he can stay there. I would imagine, just like he's been there now because of COVID. It expired in the end of May.
Okay, no more questions from me.
I still have a question, if I may. Just trying to clarify who the actual tenant is, because if you're, Mr. Kronos, if your owner is in the paving business and is the tenant then in the trucking business, and are both operating out of this site?
okay, yes, I will offer that clarification for you, sir. Thank you for the question. First, the property was bought in 2016, but Streetville Road Services. It is a company fully owned by Batista Paving, and they do contracts all over the city and for the city. They bought this site for the purposes of storing their equipment there, their paving business. They went and they spoke to the city, and in order to have embraced that use, they required some very large building on the site. And they weren't prepared to do that, but they inherited the tenant. Unbeknownst to them, they didn't do their due diligence. They inherited the tenant. The tenant is called Trump Transport, not to be confused with President Trump, and no relationship there. But that's the tenant. So we were charged with a zoning violation, and it went through the provincial offenses court thing.
Okay,
and
I don't really need all that history. I'm just trying to understand who is using the site now. Is it Trump Transport?
Trump Transport.
So the paving company is not using this site at all for their purposes, correct?
They're not, because it's not the facility that the city would embrace.
Okay, so I'm a little confused in your testimony where you're talking about your client is looking for a site to run their paving company when they're not running it here in the first place.
Correct. That's why they're selling this site, because they realize they can't do it there. They had to address the interim zoning compliance with their tenants from
Okay,
transport.
so there's no,
And now they're-
okay, so again, a little bit of confusion, because it was implied that they are looking for a site. They are not looking for a site then, or if they are looking for a site, it's totally
Irrespective, yeah.
irrelevant to this, to the issue before us.
Yes.
Because what's before us is Trump Transport, who was looking for a site.
If I misled you, I apologize
Yeah.
for the confusion, sir.
Well, yeah, I mean, good thing
And I
Mr.
was
Mr. Clemere clarified. So in fact, they bought the property in 2016 intending to use for their paving business, but because of issues with the city and what the city would have wanted to see there in order for them to do so, they did not proceed in 2016 for the last 4 years and continued with the tenant that they inherited last year, after I assume this matter came before the committee, and it was extended for 1 year to give them time to, and it
So,
was 1 year.
so I come back to the point then that the paving company is obviously operating out of some location somewhere now anyway. So its search for a new site is totally irrelevant to this. So what they have
correct,
is, a-
but yes, correct.
Correct?
But all I was trying to communicate with that was that that's the reason why they're selling the property.
okay, so that's the reason they're selling it, but that's not the reason that they're before us today. They're before us today because
absolutely
they have a
correct.
tenant who
Yes.
needs to relocate somewhere else. So it's the
Yes.
tenant's use that needs to be relocated. And so the issue is, has the tenant been searching for a new site over the last year when you got this extension? The fact that your paving company may or may not have been looking for a new site is totally irrelevant.
Yes,
think
again,
Ms.
I
Alderson-
apologize for the confusion. The very first thing that I start off with is the tenant has been looking for sites, and there's none that are available of the size required for the operation in the GTA. It's a real problem having these facilities. Everyone wants the business, and you got to be located in an area where you can serve the business, but no one wants the use. And it's very hard to find these sites, extremely difficult, unless you go to Brampton or other locations where mostly greenfields where you start up a use. So yes, they have been looking. This is why it's month to month, and we've told them.
Okay,
You
so,
know,
so, sorry, I'm gonna cut you off again, but if you're month to month with your tenant, then what is the hardship if you tell your tenant they have to vacate? The hardship is with the tenant, not with the owner of the property.
Again, sir, as we explained at the last hearing, and I'm glad to reinform the committee again, there's logistics to moving a business like that. Like, where do you take it if there's no site?
Anyway, I think Mr. Comerica is correct, Mr. Cronus. That's not you or your client's concern. If you're telling us you have, it's a completely unrelated third party storing trucks there. It has nothing to do, and there was some misleading going on there. It sort of implied, I was thinking that both parties were operating from the property. But
Oh,
now
I
we
apologize.
clarified they bought it, they couldn't use it, so they continued to rent it out. And the downside to their client, Mr. Comerica, is that they're out the rent. Then I assume they're getting paid rent for this, and his client, the third party trucker, is going to be out the rent until they sell the property. That's the downside. But there's also the appeal. So anyway, I think Ms. Alderson has a question, and then let's take when we have,
I do
we
have
have to
a
make a
question,
decision on this
actually.
because we spent enough time on this.
Mr. Cronus, I have a question. You asked us to tie the extension of the tenancy into the sale of the property. Yet there have been a number of offers to purchase that have fallen through. So what happens if the property doesn't sell within that prescribed time period?
It's why I suggested the condition to say the earlier of.
8 months.
So I would
Earlier of
advise
the
the
prior
committee
8 months.
not to tie it to that kind of wording. You either tie it to a set term if you
Yes.
choose to approve it,
Yes.
because we can't control, we're not going to sit there and
course.
search whether they sold the property or not.
Exactly.
That's exactly my point.
Yeah, and I
Okay.
think Mr.
Yeah,
Cronus,
that's
as an
fair enough.
experienced planner, would certainly understand that. So anyway, let's
Well,
take it
fair
into
enough.
committee. We need to make a decision and
A
move on.
6-month period might be appropriate under the circumstances. I understand what staff are saying.
Sorry, we missed what you just said. Not that you were asked
I
the
said
question
I
anyway.
understand. I understand what the staff are saying, and maybe as a compromise, we would agree to 6 months. So
Okay.
it's earlier than a year, but
Okay.
I think that's
Okay.
more like
Thank
it,
you.
yeah.
Let's take it in for. We need to make this. So you're in committee now. So unless there's a question put to the applicant or the neighbor, we don't need to hear from them anymore, and then we need to hear from committee members to make a decision.
I'd like to propose a motion. I think, given the facts, my initial reaction was to refuse, but given that we've gone through the coronavirus and everyone has suffered by that, I would like to propose an approval, but approval for only 6 months from May, which essentially will get you till November. So I'd like to propose a motion to
It would be October,
October, okay.
but it's not going to do much. But
No,
it's your motion.
that's the motion.
Yeah.
So can
Could,
we call it for a term,
Of
for a
six-
temporary term expiring November 30th?
Sure.
Give them 7 months. Considering 4 of them are gone already. So the question is whether we have someone.
is anyone prepared to second that?
Sorry, missed that?
I would like to make a friendly amendment to that. I mean, that's still a very tight time frame to find space for this tenant to transport everything over there.
That's not our concern.
And yeah, and then we get into the middle of winter. So I would like to do an 8-month extension from May. So what does that put us at? That puts us smack dab in the middle of winter, doesn't
December
it? January?
31st. December 31st, Laura. Yeah.
Okay.
Laura,
Well, I'd like to just make that friendly amendment that we make it until December 31st.
can I make a comment?
Yes, it's your
Okay.
motion because you
Sorry.
have to agree to that.
My comment is they've already had a year and a half to try to relocate if they've seriously been trying to look to relocate.
So the motion
Okay, so Neil?
stands. Do we have a seconder for a term expiring November 30th, 2020?
Yeah, that's the motion on the table. Seconder? Yeah, so Ms. Alderson, your friendly amendment has been rejected by the party that made the motion, so you still have the right to, if
Yeah.
you want to second that or not.
Sorry, that would give them 3 months. then.
That'd basically give them 3 months, yeah, because September, October, November. Okay. Second it?
I can agree to second. Sorry, go ahead, Neil. You're seconding that, and I'll agree to it as well.
Okay, I'll make it unanimous, I guess, because he could appeal it anyway. I don't know how long he would have get to get to T-Lab, but I think it's showing. I think, Mr. Cronus, you've heard the committee's frustration on the fact that I know there is COVID, but it sounds like they weren't doing anything. And anyway, the party who had to do something is not one of the parties that's being represented here today. It's the tenant of your client. A tenant that they in fact inherited, but they're benefiting because I assume they're being paid rent. Anyway, so that's the motion. It's been accepted, seconded, and it's unanimous. Thank you. Okay, so we'll now move on to item number 2, 67 Rathburn Road. This is an application to construct a new detached dwelling with an attached garage. There were 4 variances, and Urban Forestry is requesting condition number 2. And on this application, we have, in addition, all the materials filed with the application, absolutely nothing. There's no communication from city staff or from area residents. And we have one speaker registered, the agent, Marin Zabzuni of Contempo Studio. Are you with us?
Good morning, Mr. Chair.
Good morning.
Good morning. Can you hear me?
Yes.
I'm Marin Zabzuni, agent for 67 Rathburn.
Yes, so there's 4 variances I've introduced, and there's no comments other than Urban Forestry. I don't think we need a presentation from you, so let's just see if any of the members have any questions for you before we bring it in for a motion. Okay, everyone's good. Okay, Mr. Zabzuni, is there anything you'd like to add before I see if the committee is ready to make a motion?
I think we're content. We actually did work with city planning and made changes prior to this hearing date. So
Okay.
the planner actually is a content and supports this application. So we've been working with neighbors and planning throughout this time.
Okay, because I know we don't have any comments from neighbors. There's no petition of support or opposition, so you have engaged your neighbors.
Correct.
Thank you. Okay, committee members, any questions for the agent, or are we ready for a motion?
Sorry, just clarification. Any changes you made are reflected in the notice that we have before us. Is that correct?
Correct. The notice is up to date with the changes we already made prior to with planning.
Okay, thank you.
Okay.
Yep, I'll move for approval with the condition of forestry for the private tree permit. on the basis that it's minor and meets the 4 tests in the Planning Act.
Thank you, Mr. Palmer. Seconder for that motion. Ms. Alderson,
I can second that.
thank you. All in favor? You have unanimous approval, Mr. Zabzuni. Thank you. Have a good day.
Thank you. Thank you.
Okay. Item number 3 is 24 Nashville Avenue. It's an application to permit a parking deficiency for the proposed motorcycle dealership. There's opposition from 25 Nashville, which is a 39-unit residential building, both on behalf of the tenants and the owners of the building. And we have a planning report and a transportation condition. The planning report has a condition of approval in the event of a approval. And as I said, we do have the opposition. And we have a response from the opposition letter.
Now, Mr. Chair, the transportation condition recommends, I think, cash in lieu, which defeats the point of the variance.
All right, okay.
Kind of double dipping.
Yeah, perhaps we can hear from the applicant on that. The applicant is Doug Goss. Mr. Goss, are you with us?
Yes, I am. Thank you.
Okay, so Secretary Treasurer just pointed out that the transportation condition is sort of defeats the purpose of the variance. They want you to make payment for cash in lieu. We do have the opposition letter, and we have your response to the opposition letter. We have your cover letter. And I assume you're content with the planning condition that in the event of approval, you've reviewed the condition and you're okay with that?
Yes, I worked with planning, and we discussed it. And I'm totally support their condition.
Okay, but the transportation condition?
It's in conflict with the variance.
Correct.
So
okay.
my intention is, yeah.
Okay, let's just see if any of the members have any questions for us. So the question is, I have a question. The parking, that as opposed to motorcycle storage, those are two different things, sir? In other words,
Yeah,
you have to have
that's correct.
space to park the vehicles, the motorcycles and the scooters you're selling, and then also the parking spots are not to park the 20 to 25 motorcycles as stated in the tenant's power sports letter back to the councillor. I guess they included the councillor as well as the committee.
So the parking spots are at the rear of the building, and those are parking spots, I guess, for automobiles. The majority of our traffic is on 2 wheels, and the majority of our business is service related. We have all the service bikes essentially live inside, if you will.
I'm having trouble hearing. If you could try to speak a little clearer.
Of course. So we have the outside parking spaces are really for cars, for motorcycles, and for service. We have a lot of space indoors for service vehicles. So really, there's more than sufficient parking for any automobiles that show up or any staff members, of which there's only 2 with automobiles.
Okay, and just to clarify, so you're with Power Sports. That's the tenant,
correct.
right? So
That's
I see
correct.
in your letter you point out that the photographs and commentary and the abuse of parking spaces are with respect to 22 Nashville and not 24.
That is correct.
Okay,
That's
important.
They're our neighbors. They're the neighbors, but that's not us at all.
right. Okay, that's.
I did look at the photographs, and that's entirely correct.
Thank you, Ms. Alderson. Any further questions, or is someone ready to make a motion on this?
Question.
Yes, Mr. Kamara.
Okay, so my understanding is that there will be 7 parking spaces provided. Are those 7 parking spaces going to be used for motorcycle parking or for automobile parking?
The 7 spaces are for automobile and motorcycle. If someone shows up to, for whatever reason, they can park a motorcycle in there. You can fit 4 or 5 motorcycles in one parking spot.
Okay, so you're not planning on designating them specifically for motorcycles. You will be accommodating automobiles as well.
We will. I mean, we've been in business a long time, and we don't generally have that many automobiles show up.
So, okay, but so whether it's an automobile, someone will come in to go to buy a motorcycle, whether they show up on their old motorcycle or on a car is really not a distinction. But the question is, whether those 7 spots are for visitors as opposed to your inventory of the motorcycles you have for sale.
Oh,
That's, I think,
oh,
what
I'm
we're
sorry,
trying to get at.
Oh, I'm sorry, I misunderstood the question. So those are visitors parking.
Okay.
Yeah.
So you park your actual inventory somewhere else, that's not on those 7 spots. I think that's an important thing
That's
to
correct.
clarify. Perfect. Okay.
Sorry, I misunderstood you. Yeah, inventory's inside.
Someone ready to make a motion?
Is there someone to speak in opposition
No.
on this?
Nope. We have only one speaker. We do have the letter, though. And we have the response that Mr. Goss wrote to the letter.
Okay.
And Mr. Goss, you're okay with planning conditions that it be limited to 25%?
Yeah, I mentioned that I asked him that at the outset.
Yeah, I was in discussion with planning, and we were. Yes, I'm very supportive of it. It's fine.
The motorcycle sales, sorry, yes, okay.
Yeah, that's correct.
Okay, so I guess I'll make a motion then for approval. I'm actually hearing some feedback from my voice, so it's making it difficult. Are you hearing me okay? I'll make a motion.
Yeah, we're hearing you. It's
Little
a little bit. It's we hear you clearer than we heard the applicant. So it's not
Okay.
perfect, but we
I'll
can
make
hear
a
you.
motion for approval then. I believe it is minor in nature based on the full text, and it's just conditional on the applicant agreeing to the 25% in motorcycle sales only, so that's limited to 25%. But I'll make that motion, yeah.
Okay, we seconder for the motion.
I'll second that. And just to clarify, because I think it was hard to hear, I believe what's being proposed in the motion is that it is conditional as per the planning condition?
Yes. That it be limited to 25% in motorcycle sales, yes.
Okay, all in favor? You have unanimous approval, sir. Thank you.
Thank you.
Okay, the next application is item number 4, 30 Woolton Crescent. Actually, Laura, maybe can you try muting and we can figure out if the feedback is coming from you? Okay, I think it was, but anyway. Okay, so item number 4 is an application to construct a new detached dwelling with an attached garage. There are 5 variances. TRCA has no objection. Urban Forestry is looking to defer, deny, or apply for a permit to injure a tree. And we have one speaker, the agent, Mr. Romano. Hello, sir.
Good morning, Mr. Chairman, members of the committee. How's everybody this morning?
Very good, sir. How are you?
Pretty fine, thanks so far.
Okay, so there's no other speakers. There's no letters of opposition or support. Or let us know what's gone on. We've seen your variances. Committee members wish a presentation from Mr. Romano? Okay, is there anyone have any questions?
Mr. Romano, your client is aware of the forestry conditions?
Yes, we're satisfied with the forestry conditions, and I'm happy to speak to planning's concerns if you'd like me to walk through the site plan and my presentation slides.
I don't have any forestry conditions for this file.
There's a ravine, I think. That was it.
I see forestry and TRCA.
Well, the comments are from Ravine, but when you look at the chart, they haven't checked off any of the conditions.
Okay. The TRC said they have no
Correct.
objection. And then forestry, don't we have the...
It's labeled forestry in your
labeled.
agenda. It should be Ravine. And then when you look at
Ravine,
the
yep.
chart, For 30 Woolton, none of the conditions are checked off.
Yeah, item 4 isn't on the forestry checklist.
It's on, but nothing's checked off.
Yes, that's just it. They haven't.
That's right.
Yeah.
There are no tree
They don't list
injuries
all
or
the units. They
removals.
only list. A little confused then. There's 3, 4, 6, 8, 9, and 11 only. So you'd think that those are ones they didn't list all 20 applications. So
No, so Ravine only reviews the ones that are applicable to them. And in, for
Right.
this whole agenda, anything that they reviewed, they haven't recommended any conditions.
right, this one they is subject to their review, but I'm saying the normal urban forestry, it's on the checklist, but nothing's been checked off.
Correct.
Okay, perfect. Okay, any further questions for Mr. Romano? Are we ready for a motion? The front
I just-
elevations and put up on a slide there.
Okay. I just had a slight concern with regards to the proposed dwelling depth and length.
I can speak to that.
Please.
So if you look at the site plan, that's the first slide. I have a markup of the first slide. Thank you kindly. So
Oh, I see.
this property has a ravine. It's also next to the green belt on that north side. So there is no north side yard neighbor.
I see.
And the attached garage is basically positioned where it'd be acceptable to TRCA. So if it was detached, it'd actually be closer to the side lot line and close to the building, and it would still count as length. So the site plan actually has a broken line that shows the second floor, and I've just put that in red so that it's more clear. And if you attach an approval condition to build substantially in accordance with the site plan drawing, it'll make sure that only the garage is affected by
reflected.
that length and depth, because the dwelling itself from the front wall to the second floor is like 17.6 meters on the north side and 17.2 meters on the north side and 15.6 meters on the south side. So I think it responds appropriately to the site constraints and the natural environment that surrounds it and has no impact on anyone. So again, I would suggest tying it to the site plan, and that would make sure that those setbacks are in length are only for the garage.
Thank you.
You're welcome.
Okay.
Based on that, I would like to move approval, subject to it being tied to the site plan. And otherwise, I believe it meets the 4 tests and is minor in nature.
Okay, thank you, Mr. Merritt. Seconded by Mr. Palmer. All in favor? You have unanimous approval. Thank you, Mr.
Thank you
Romano.
kindly. Enjoy your day.
You too.
Bye.
Okay, the next application is item number 5. 42 Agar Crescent. It's an application for a new detached dwelling with an attached garage, and there are 8 variances. Planning is recommending refusal of variances 2, 3, 4, and 5. There was, I think, previous application for a. No, I have a note here about review, something about widening the driveway. In any event, let's hear from the applicant about that. Chris Pereira is registered as the agent, and we have Doni Diodati at 44 right next door, who's registered to speak with concerns. And we do have Urban Forestry also requesting a denial due to the effect on trees and where trees would be planted. Okay, is Mr. Pereira there?
I am here, yes.
Welcome. I assume you've read the planning report. I don't know if you've spoken to the neighbor and know what the neighbor's concerns are, but can you give us a presentation, 5-minute presentation of your application, why it's should be merit support from the committee? notwithstanding what planning has to say.
Good. Right. Good morning, Mr. Chair, members of the committee. My name is Chris Pereira. I'm the principal of Embahar Planning and Design Limited. We're located at 25 Valleywood Drive up in Markham, Ontario. Having actually just been recently retained by my client on this particular application, I would like to formally request this item be deferred to allow us a little bit more time to continue working with staff to hopefully address a few of those issues that they have identified in the report, as well as the forestry matters as well. So there's a couple of things that we'd like to take a closer look at, and we would appreciate the time to do so. So I'm hereby formally requesting that this item be deferred.
Okay, so you're saying you weren't involved with preparing the plans or the application. You've just been retained now because of the planning report or the negative report.
To be fair to everyone else, this report was submitted in July, so the applicant would have been aware of these comments before it was even scheduled for this hearing.
Yeah, July 27th. Madam Secretary Treasurer, what was the applicant looking at in terms of this matter is deferred in terms of getting back on an agenda?
It probably won't be this year.
Okay, committee members, any questions for the applicant or on the matter of deferral? I guess we should hear from the neighbor, 44, Donnie Diodati, on the issue of the deferral request.
Yes, good morning, Chair and committee members. Thank you for letting me speak.
Yeah,
the deferral is a bit of a surprise.
Yeah, we don't want to hear from you right now on the merits. We just have to hear from you on the issue of the deferral request. And I'd like to know when you include that response to let us know whether the neighbor, or I guess this agent says he was just, whether a neighbor or a previous agent has spoken to you about this or come to show you the plans or not.
So to comment on that, no, there has been no neighbor outreach, not to me specifically, and I have spoken to 4 other neighbors in the vicinity, and no one has stated any sort of outreach, which is a bit of a disappointment. But no, there has been no outreach by the applicant or the agent on this application.
Sure, you would have been the one because you're right next door, so you would have been the logical.
Yes.
And I assume there's another neighbor on the other side at number 40 and 42. So you're at 44, then be the neighbor at 40. I assume they were also not consulted. So on the issue of the request for deferral, and I guess until it's at his peril, he wouldn't be able to get on an agenda this year. So it just means, I don't know if you have an opinion on that, but at least with COVID, you didn't have to drive all the way down here to Etobicoke Civic Center in terms of being inconvenienced by a last-minute request for a deferral.
Yeah, that's okay. It's not far, but if the agent or that's plugged in right now is listening, I really seriously hope that they do reconsider this entire proposal, because it goes well beyond what is acceptable as fitting within the neighborhood context.
Yeah, we will certainly note that.
I do hope that they strongly reconsider all of these variances. It will not at all fit within the neighborhood context.
Okay, thank you. I didn't want to hear from you on the merits, but I appreciate that, and I appreciate that will be put in in the minutes of this meeting that you've stated that, and as well. I assume the committee member who makes the motion will say that the purpose of the motion is to, convene and to discuss with city staff and affected area neighbors, and to make changes in light of the negative comments from planning and what you've had to say. Okay. Okay, so let's take it into committee on the issue of the deferral request by the agent, Mr. Pereira.
I would say use the time constructively because these variances are not minor as they are before us.
Okay, thank you, Mr. Palmer. Seconder for Mr. Palmer's motion.
Why did you make a motion? I'll make the motion. I'll make the motion. That's fine.
Everyone has their hands up. Laura too. So.
Laura, unless you want to go, but I would move.
No, I just Go ahead.
Okay, I'll
ahead,
move
Stan.
to defer in order to allow the client time to process with neighbors and with planning to bring forward an application that's closer to, that's more compliant with the zoning bylaw.
Okay, thank you. Seconded by
I can
Ms.
second that
Alderson.
motion.
Okay, all in favor? Matter is deferred. Okay, thank you, Mr. Pereira.
Thank you.
Thank you, Mr. Diodati. Okay, we'll move on to item number 6, 53 Thicket Road. It's an application for, I think, some additions. Hold on. This is an application to construct a second-story addition above the existing dwelling and to extend the existing attached garage. There are 4 variances. Urban Forestry is requesting condition number 2. We have supporting materials and support from neighbors. Ravines has a condition as well. And we have registered as a speaker Lena Rodriguez as agent. No other speakers registered. No neighbors. We have supporting materials with photos, and we have support from 39 Thicket. Hello, is Lena there? Lena?
Yes, good morning. Good morning, Mr. Chairman and members of the committee. My name is Lena Rodriguez, and I'm the agent for this application.
Okay, welcome. So you're aware,
Thank you.
Ravines, what did Ravines have to?
I don't think they have it.
I don't think they have a condition. Again, it's not, it's in the, there's a list, but it's not checked off.
It's just forestry.
Not yet, just forestry. There's nothing. It's funny, this is another one where Ravines, are they giving us a list, but nothing's checked off. So
Yeah.
perhaps we can check that for
Yeah.
the next hearing to clarify what that means. Ms. Rodriguez, if nothing you'd like to add, let's just see if committee members have any questions, because there's nobody here with opposition. I assume you're okay with the urban forestry condition?
Yes, the forestry condition is number 2.
Yeah.
Number 2. Yeah.
Correct.
Yes.
Okay. So committee members, do you have any questions for the agent, or are we ready for a motion?
I have no questions.
Okay. I'm just looking at this memo again. You know, we looked at it in another application here this morning. So it refers to items 3, 4, 6, 8, 9, and 11. The conditions aren't checked off, but there are noted, I just note here, advisory comments. So perhaps, Madam Secretary Treasurer, these advisory comments, is that what they are? They're just advisory comments?
That's just their standard memo. They're
Right, but I'm just saying the fact that they didn't check anything off, but they list 6 of the applications here. I just like to
Properties,
get
yeah.
some
It's ambiguous,
clarification of
actually, I think.
what that
I thi-
exactly means.
what they're trying to show is that they have reviewed it from their perspective and that they do not have
Okay,
comments on these
for those
files.
specific 6 applications, yeah, they just,
Whereas if they didn't provide comments, people may say, well, does
Right.
Ravine have an issue?
it's sort of like
This
when we
way-
get a report from planning for information where they basically just, whether it's, they just don't want to say they approve it, but they just go through the analysis without actually saying that. Okay. So any questions for the applicant, or are we ready to have for a motion on this one?
I'm good if no one else is going to go.
Yep.
I'd like to, I believe the application is minor and meets the Ford test. I would therefore like to propose a motion to approve, subject to forestry condition number 2.
Thank you, Mr. Merrick. Seconded for that motion.
I'll second.
Okay. Mr. Palmer. Although we're actually, there's a time delay, so in fairness, we should give it to Laura. So, okay, seconded by Laura Alderson. All in favor? Okay. We don't get paid extra to move for second motions. Okay, so you have your approval, Ms. Rodriguez. Thank you. Okay, the next.
Thank you very much.
Okay, Next application is number 7, 103 Lawnside Drive. It's an application for 2-story rear and west side additions and a new detached garage in the rear yard. And we have on this application nothing whatsoever, no communication from neighbors or city departments. And we have registered as agent. The name kind of got butchered on my sheet here, but we know who it is. It's Mr. Benkowski, Jonathan Benkowski. Correct?
Good morning, sir.
Good morning.
Correct.
Yeah, they butchered your name
Correct.
here a bit, but
Already
we
as
know
well.
who you are.
I'm used to it my whole life.
So, sir, there's only there's 5 variances here. Would you like to add anything, or just see if committee members have any questions for you?
I can take any questions if committee members have any at the time.
Okay. Have you spoken to any of the neighbors? Because I don't see any letters of support or opposition.
We have not, but what we have done throughout the time was we worked with planning to adjust the proposal to bring it to the level of acceptability from planning. There is already an existing detached garage on the property now. The existing detached garage is presently located more towards the front portion of the dwelling. We're actually proposing to push that to the rear. So essentially the dwellings that are, the variances that are before you today, other than the side yard setback at 1.2 meters, really deals with the garage itself.
Right. Yeah, so you pushed, I'm sure that, you're pushing it towards the back to the, there's a small variance for half a meter from the rear lot line for that garage.
Correct.
Yep. Okay. Any questions for Mr. Benkowski?
How do you
have a
access-
speaker here as well with concerns on behalf of Mr. and Mrs. Greco. I'm not sure it says where they live, but we'll hear from. Sir, you aware we have a neighbor here, or someone representing a neighbor? Chiara and Antonio Paniccia representing Giovanni and Ida Greco, and I'm not sure what their address is. Mr. Benkowski, are you aware? Okay, perhaps we can hear their concerns and you'll have a chance, but I'd like to also know where they, what their concerns are in relation to where they reside. So we'll find out. Okay, is Mr. and Mrs. Paniccia there, please, with us?
Yes, we are.
Okay, so can you tell us who you are and what your relationship is to this application and to the Grecos, or what their relationship, where they reside?
Yes, good morning, Mr. Chairman and committee members. Thank you for allowing me to speak. I'm representing the neighbors to the west side, 101 Lawnside Drive.
101, okay. And you are Antonio, correct? You're Antonio?
I'm Antonio, and my wife is Chiara. The owners of 101 Lawnside Drive are my wife's parents, my in-laws.
Okay, so you're representing it says here the address, 101 Lawnside. So it's your in-laws who are the next door neighbors.
Yes.
Correct? Okay, now I know who you are. That's wonderful. Okay, so let us know what your concerns are, and let us know whether you've I guess you haven't spoken to your neighbors or they've consulted you, but
No, I have not.
just let us know what your concerns are on behalf of your in-laws.
Okay. So it's regarding item number 2, which is the side yard setback variance request.
Yep.
A part of the package that was included with this item was the survey certificate.
Yes.
And I believe on the survey certificate, it shows that the current driveway has encroached on my in-laws' property. So there's a measured item and a K dimension. If I'm reading correctly, I think there's a slight encroachment onto the property, and I want to make sure if you agree to the setback request that it's measured to the lot line, not to the actual measured
That would be the lot.
driveway.
So you're looking at variance
You can see
number
there's
2.
two
It's the
lines. There's
side,
two lines.
the
One's a solid line and one is a thinner line. Is that indicating that there's a property?
you know what? The committee members here are not Either myself or the other committee members can sort of give you legal advice. But having said that, so you're talking about the west, the side where there is a variance, or the side your in-law side doesn't have a variance, so it would be the 1.8.
So where you're asking for the variance of
The 1.2 is the west side lot line.
1.2. Yeah, I want to make sure it's measured to the property line, not to the existing driveway, because I think the previous owner encroached on my in-law's property when he built that driveway.
Well, I can tell you that as you read the
see that
variances are always measured from the lot line. That's what it says. It's 1.2 meters from the west side lot line, not from a physical, like a driveway or something like that. It obviously refers to the property limits. Yeah.
Okay.
So
The
you're
other,
saying, has there
concern,
been an
obviously-
encroachment, or are you saying that there's been an encroachment? They are going to be moving the
It appears
garage,
on the
correct?
survey that it is.
Yeah, they're moving the garage. I have to expand my. Committee members know what, see what the neighbor is referring to? So 101. Okay, the application is 103, and you were at 101. So again, that's something you have to look into in terms of the driveway, but it's showing where the pavers are and where the concrete. And also, again, perhaps, and we saw the garage. So perhaps we can hear from Mr. Benkowski in response about the information with the garage, but the garage is being pushed to the further back on the lot, to the rear of the lot.
It's actually ahead of the garage where the dimensions change. I think it's more the driveway.
The driveway to the street.
If you see, there's a dimension that says 1.8 meters measured, and then there's below there's 1.816 K. I think that's where just maybe a little bit behind that is where the deviation starts. It doesn't go all the way. Doesn't go all the way to the back of the property line.
Only goes to the street.
Only where the driveway was built, I think, in front of the garage.
That was just Mr. Benkowski speaking, correct?
No,
Or that was the
that was,
neighbor? Okay, Mr.
Mr.
Benkowski, could you like to respond to, take a look at the survey and just confirm that, the setbacks are from the property line? And if there's any further about in conjunction with the relocation of the garage to the rear of the lot, further back, is there any other, anything else in terms of the paving and what else is being done there?
Yes, it's actually the opposite. So the thick black line on the survey that's up right now is actually the property line.
Okay.
The thinner inner line where it says concrete curb is actually within 103 itself. So today, I know it's a little bit misleading just because you have two lines that are so close together, but today there actually is no encroachment, and there would never be a proposed encroachment onto a neighbor's property.
Right.
And to answer the additional question, all measurements are taken from a lot line of the actual property itself.
Right.
So there wouldn't be any measurement taken from an encroachment into somebody else's property.
Right, so the thin line looks like it's closer to the 103 side, so in fact,
Correct.
is in fact the opposite, that in fact the neighbor, the Greco's driveway is in fact encroaching on the subject property?
I just think it's a concrete curb. I don't really think there's any encroachment really taking
Right.
place. I just think that's where the concrete curb is between the two properties itself.
Right, so-
But for the concern of an encroachment, there is no encroachment proposed.
Okay, thank you. Okay, committee members, any questions for either the Mr. Benkowski or Mr. Panacea, or are we ready for a motion?
Question for the applicant. So the garage in the rear yard, what's the purpose of it?
It is actually for vehicles. The owner has 4 vehicles, and he also races cars. So he plans on storing his car he would take to motorsport and things like that. This is not proposed to have any type of storage in it at all. It truly is a rear garage for them to store cars in.
Okay, and is he going to drive through the house, I guess? Because does the garage go all the way through the...
You are absolutely correct. What we did work on with planning was to eliminate any type of landscaping issues at the rear, and that really alleviated planning's concerns by not requesting a landscaping variance in the rear yard. But yes, the idea is to be able to drive through the dwelling, as well as parking his everyday car in the garage, and the car he races and the cars he stores would go into the garage at the rear.
Okay, thank you.
Okay. Okay, any further questions, or we ready for a motion?
I'm good.
I'm good too. Don't everyone go at once.
All
I'll
right,
make a motion
all
for
right.
approval.
Okay, thank
I'll
you.
make a motion for approval. We have nothing from community planning, forestry, or transportation, so it's
No
relatively
conditions.
straightforward in nature. I believe it meets the 4 tests, and that's my motion.
Okay, thank you, Ms. Alderson. Seconded for the motion. Mr. Kamarick, all in favor? Unanimous approval, Mr. Binkowski. Thank you very much. And thank you, neighbor. Okay. Okay, the next application is item number 8, 107 Trustee Drive. This is an application to construct a 2-story rear addition, a 2nd-story addition above the existing dwelling, and a 2nd-story rear platform, and to create a secondary suite. There are 4 variances. We have support from area neighbors, including 101, 103, 105, Trustee. We have a condition from Ravines, and planning is looking for a condition that it be built substantially in accordance with the elevation plans in the event of an approval. And there are 4 variances. And there was one issue about, we'd like to hear about the platform. The rear is, 2nd-story platform is oversized as well, I note. Planning has, as I said, wants to have a condition of approval. And we have support as well. So registered to speak on this application is Ben Baghati, and nobody else registered to speak. Sir, are you with us?
Yes, good morning, Mr. Chairman. Good morning, committee. My name is Bamdad Baghdadi.
Yeah, can you speak a little louder, sir?
Yes, good morning, Mr. Chairman. Good morning, committee. My name is Bamdad Baghdadi. They call me Ben. I'm the architect and acting agent for this property.
Okay, sir, you're aware of the conditions being requested from community planning?
Yes, I do, and I have a request for that. But before that, if committee members have any questions or concerns, I would like to answer those first.
Yes. Okay, so why don't you just tell us what you want us to know about the proposed condition from, I see we also have from Ravines and planning, and why your application is worthy of support, and then we'll see if they have any questions once you've stated that.
Sure. Ravine basically didn't check off on any of those boxes. We have submitted Ravine application and have the arborist report. They're more or less in line with our application and didn't have any major complaint or comments towards our application. My request is in regards to the planning condition that the decision is tied to the elevation plans. First of all, that plan wording should be elevation drawing, not the floor plans. And also, since we are under Ravine approval, they might ask me to change something on the drawing, maybe reduce the setback, increase the setback on the west side, or reduce the length of the dwelling. That will, in fact, change my elevation. And if the committee tied the decision to the elevation, and the Ravine asked me to change anything which will result in the change in elevation, then I have to come back to committee again.
Not really.
So I would like to
you're talking about things that are variances. If it's a variance and you got the variance, then they can't ask you to move it any different. So I'm just wondering why you have a concern about that. You're applying for variances. If you get that variance, then that's what it is. If it's something else, I understand that's not a variance. I understand that concern. Right?
I understand your points, Mr. Chairman. If Ravin asked me to, let's say, reduce my depth of the building by pushing the wall back, that will change my elevation.
Okay, but sir, can you read that the letter when they say they want it to tie to plans? They explain why. They don't do that on every application. In this case, they're saying the proposed dwelling has an irregular shape on the west side and steps in twice, and that the lot is a pie shape narrowing towards the rear. Right? The side yard setback of 0.88 is required for the middle corner of the west side where the proposed second floor addition overhangs. So it's very specific. They're not going to give you, they don't want us to give you a straight west side setback that doesn't reflect what you've told the planning department you're going to do, because you could conceivably do something else and not respect those jogs that they're talking about. So if you have a particular plan where it says your proposed development should be constructed in accordance with the elevation plans, if you think it should be restricted to perhaps just one plan or one drawing in terms of what that concern, and Ravines is not going to make you any changes that affect the side yard setback. So that's why they're doing it, and I think it's a reasonable request, and I don't think it affects your any concern you have that anything else that TRCA would ask you to do subsequently. It's a very common thing, and for that particular reason that the planning technician noted in the report.
Okay,
So
Mr.
that's
Chairman,
my
I
opinion.
agree.
I don't know about anybody else. So I see you do have some letters of support from the neighbors, which I mentioned in my opening remarks.
Yes.
So committee members, any further questions from, even including what we would tie that approval to? Because I think if you read the report, there's a reason to do that.
Mr. Chair, I would just like to get a clarification from staff. I believe this proposed condition says substantially in accordance. It's not saying exactly as per. So if he's forced to reduce beyond what his approval is now, I'm assuming he does not need to come back to committee for that reason.
Right, so planning will have an opportunity to clear that condition for building permit. Should they remove a window or do something like that that is minor, it's within their purview to accept that. So if they're reducing something, I don't think they would object. It's to make sure they don't increase something.
Yes, and the issue is as well, like I just stated, it's with respect to this planning conditions because of the side yard setback. TRCA's concern is going to be with respect to the rear yard, not the side yard. So I don't think there's any, for what you just clarified for Mr. Kamarick and what the fact that TRC is not going to be dealing with the side yards, I think we're okay imposing that requested condition. That's my opinion. Is there any other further questions from Mr. Beghati, or are we ready for a motion?
I'll move for approval. It meets the 4 tests in the Planning Act. It's minor. Subject to the planning condition tying it to the plan stated July 10th, 2020.
Okay, so it's as stated in the condition?
Yes.
Okay, thank you. Seconder for Mr. Palmer's motion.
I can second that.
Thank you, Ms. Alderson. All in favor? Unanimous approval. Thank you, Mr. Beghati.
Thank you, Mr. Chairman. Thank you for me.
Okay, have a good day. Okay, next application is item number 9, 2575 Islington Avenue. It's an application to construct a new detached garage with a new detached dwelling with an attached garage. Looks very minor. We have 2 variances only. One of them is a large FSI variance from 0.45 to 0.8, and then as well as the height of the main pedestrian entrance above the established grade. We have registered to speak on this item Nick Wood from Corbett Land Strategies. We do have a covering letter explaining and a planning justification, as well as input from Forestry. No, we don't have anything from Forestry. So the issue here, it looks like, is the issue of the
density.
on the density, and the issue is because of the elevations and the slot slopes that a portion of the basement is included in the lot calculations, and would otherwise, they pointed, come in at 0.5016. Planning is recommending refusal on the basis that the 0.8 in any event, even if you took that into consideration about the basement, would work out to 0.64, which they feel is excessive. And we also have an opposition letter from 14 Stewart. So, Mr. Wood.
Good morning, Mr. Chair.
Good morning, sir.
Committee members.
Okay.
Yeah.
Could you give us, an explanation, this intricacies that you're asking for 0.8, the fact that community planning acknowledges that the portion of the basement is included, but they still feel it's excessive, even when you account for that.
For sure. Thanks for this opportunity. Good morning, Mr. Chair, committee members. My name is Nick Wood. I am the agent with Corporate Land Strategies. We've been working with the owner of this property for some time, and what's before you is a single detached dwelling which would complete 4 lots along this stretch of Islington. These lots were severed back in 1994, and that the permitted FSI currently is 0.5016, as you stated. So what we're seeking before is an increase of an FSI of 0.8, because we note that the lot of the subject lands is significantly deeper than the adjacent lots. And we would also note that there's a significant grade change from our lot to the rear property. That grade change would result in about 4 to 5 meters of change and our lot is situated below the rear lot. So impact from this, from our request would be minimal, and that the 4 buildings along this stretch are subject to an existing building permit that's been approved. But the request is just looking for a revision to this approval. The floor space index, the area that's going to be expanded is just in the rear portion. So the existing side yard setbacks and height will be maintained as per the approved building permit. So for pedestrians or cars driving alongside, the requested increase to the floor space will not be seen from the street. So it will be negligible. And in addition, what we've taken a look at some of the previous minor variance decisions in this immediate area, and note that there are several approvals that have been granted for these floor space index, but just that we would like to point out that this wouldn't be a precedent. The increases to these other floor space indexes that have been approved would have resulted in floor areas that are greater. I think there's about 5 or 6 floor buildings that have been approved which would have a greater floor area.
Okay.
So I think we would like to submit that.
But okay, my question is to you, but those other properties, and it relates back to the question I have for you. This lot was severed in 1994? This lot was created by a severance in 94, correct? And at that time, was a new house built on the lot?
No, it's vacant.
No, it was left vacant.
Okay, it was left vacant. So the question is, that was 94. It is a long time ago. At least it wasn't, 6 months ago. And you were approved at 0.5016. Now you're looking to go to 8, which in fact is 0.64, giving you the benefit of the doubt. It's at 6.64, which community planning and the neighbor, I believe, you look at his letter, he sort of thinks, he says he would sort of think he would agree to 0.10 to a 0.15 increase on the FSI. So I don't know if that's over the 0.45. It's hard to know because he's not here, whether he feels it should be from 0.45 to 0.55 or from the existing 0.50 to 60. You're at 0.64, which translates to 8 because of the issue of the basement. So I'm a little confused in terms of what the neighbor is saying he'd agree to, but community planning is clear that they feel this is excessive. Right? So.
Yeah, if I could respectfully submit to
Yeah.
the city staff did approach us with a suggestion to reduce our FSI
Yeah.
to 0.7, I believe. The reason we didn't agree to that was just mainly the cost. Our client is a local developer, not a large scale developer, so the cost on redoing the architectural drawings and some of the engineering studies, sure, it would be kind of excessive. So
It's interesting. Well, to make revision, because you know what, I've been doing this over 20 years, and I've never had someone come and say to me that the reason they don't want to comply is because they have to redo or revise their drawings. But in any way, I'm seeing here they have said that typically the FSI approved variances in the range of 0.54 to 0.59, and they do admit that you're at 0.64, not at 0.8. So that's where we are. Let's see if committee members have any questions for you. And, you know, I invite everyone to take a look at the neighbor's letter. He says he doesn't agree with the proposed changes. He believes that this is not a minor variance. He will agree to 1.0 to 0.15 increase. And again, I don't know if that's what he means by that, but that's where we have it. But I don't know if they'd have to completely redo their plans or just revise them, but that is certainly not something that's going to sway the committee in making a decision that will cost money to change your plans. No offense taken by, I'm just telling you, I've never heard that given as a
I
reason.
do have a question of Mr. Wood.
Okay, go ahead.
Mr. Wood, are you representing a developer here today?
That's right. The owner of the property is also constructing the units here. So we're representing the owner.
This is for speculation purposes. This is not for him to live in. Is that correct?
He would be selling the unit. That's correct.
Okay, I just need a clarification.
Okay, I don't.
Thank you.
Anyway, I really don't. My opinion is that's not really something that we should be taking into consideration. It's not relevant whether it's a developer, a big developer, a small developer, the biggest. You know, it's
It doesn't change the planning
and,
there.
it doesn't change anything that we have to consider.
Well, the reason
Whether it's
I'm
being done
asking
by a
because he said it was
developer
about
to
the
sell
cost
or
of
for
doing
someone to
new
live in.
plans.
Sorry.
The reason I asked is because he brought up the cost of new plans as being a deterrent.
Okay. Yeah. Interesting. So
Fair
yeah.
enough.
So
So I'm
not
tying
only
it to that.
Okay. Thank you for that. So you're right. Even it's even more so than a poor homeowner doing this for a place to live in.
Exactly.
It is a developer. So that point is taken. But I just wanted to point out that in the normal course, we're not supposed to have an adverse.
Hey, Jason. Yeah, so the YouTube channel just paused, but so what they paused the actual hearing like mid, and so they haven't delivered their decision.
Sorry, Mr. Wood.
Yeah.
Hi. Sorry, we're having trouble putting you on mute. So if you could just mute yourself, and you can.
Sure. Yeah, I was just kind of speaking to my client. That's all right.
Yeah. Sorry, I'm just having a hard time putting you on mute. So if you want to mute yourself, then you can you can continue speaking to your client. Sorry about that.
For us? I've been struggling to get into anything today.
I know what's going on. It's a weird, weird thing, but it seems like we're back.
I thought the connectivity was better than
Yeah, I know. Honestly, sometimes when we have, like, it'll just go out and then come back, and there's no real, like, rhyme or reason why it does that. It's just like,
Okay, everyone, we're back now.
Okay, so we're ready to reconvene. So we're in the middle of item number 9. We were just dealing with the issue of the FSI and the 0.6 floor that results in 0.8, and the planning memo that says that what's reasonable in the area is, I think, 0.54 to 0.59 times the area of the lot. And the applicant has just told us that planning was prepared to agree to, or 0.7. Mr. Wood, you're You're back with us?
Yes, can you hear me?
Yep.
Okay, excellent. Yeah, we would, I think the one committee member was about to ask if we would accept 0.7 FSI. We would, if that's presented before us here. And we would also like to note too that the 4 lots of which this subject property is located on the most immediate south are currently under construction, and they are subject to an existing approved building permit alongside of this lot as well. So,
So is that also based on the 1994 approval?
they are.
So they're being built on based on the approval granted at that time?
They are. And the increased height and has not been changed at all from what's been approved.
So are those being built at approximately the 0.5016 that was approved on this particular lot, or at a different number? And again, do those lots also have the issue with the basement? Or just this
they
one?
are subject. They are subject to that grade change.
Okay.
They are. The one has an approved FSI of, I believe it's 1.07 at the most eastern lot.
Yeah, because they're much smaller lots.
Oh, because they're smaller lots. So it's what Mr.
They
Kamarick
are.
was saying, that in terms of compatibility, if this is a bigger lot and you gave them even a bigger FSI, it would even be that much. In fact, that the bigger lot should have the smaller, and the smaller lot have the bigger, which is sounds like what you have on that property. That's why you got the higher FSI on that property, because it was a smaller property in order for it to be consistent.
Visually, you can't tell the depth from the street. So.
Yes, yeah, because so it's not in the frontages.
It's the depth.
It's the depth that makes those lots bigger.
Mm-hmm.
Okay, so let's see if there's any further questions now that we've reconvened and figured out where we were. And I think, Mr. Kamarick, you were in the middle of this, or
kind of.
Anyone else have any follow-up questions then based on this? It sounds like he's the applicant, the agent has said he would be prepared to accept 0.7, which if you extrapolate the 0.8 would be 0.64. The 0.7 would be in the range of what city planning was talking about in their memo at 0.54 to 0.59. So is anyone ready to make a motion based on that?
I'll try. I'd like to move approval, seeing that I believe it is minor, meets the 4 tests. I would like that approval to be based on a amended variance number 1 to 0.7, and with the condition of forestry number 3.
Thank you, Mr. Kamarick. Seconded for Mr. Kamarick's motion. Ms. Alderson, all in favor? Unanimous approval. Thank you, Mr. Wood.
Thank you for your time.
Okay, have a good day.
You as well.
Okay, item number 10 is 615 Browns Line. This is an application to construct a new fourplex, and there are 8 variances. Sorry. Okay. So there are 8 variances. Planning is recommending refusal. They mentioned that there are only 6 variances in their memo, I noted. And the rationale is that fourplex is not permitted.
Right.
We have a copy of their memo. We have as speakers registered on this application the agent, Nick Saccone, as well as the neighbor at 623 Browns Line, Mary Borges, registered. So let's, Mr. Saccone, are you with us?
Yes, I am.
Okay. Also, Urban Forestry is requesting refusal of this application as well, in addition to community planning. Can you give us a presentation, sir, based on you've seen the planning report?
Yes, I did. I did speak with transportation.
Can you try? You're a little muffled. It sounds like you're. Can you try to speak a little clearer and see if there's a problem?
Hello? Yep. Can you hear me now?
Yes. A little better.
Okay, so I did speak with transportation Forestry, I was able to get them via email very briefly. So by the sound of both transportation and forestry, the number 8 variance was causing a little bit of hiccup on their end. So if I could remove this number 8 variance, and I'll comply by removing one spot closest to that, I guess, the rear lot line tree.
Okay, so hold on. There's
and-
8 variances here in the planning. So you're talking about variance number 8, which is the required minimum parking width of 2.9
Correct.
to 2.62. So you're saying you can remove that variance?
Yeah, I could remove that variance, and by removing that variance, number 7 variance actually goes to 28 square meters.
I
instead of
see. So in other words, by doing that, you can eliminate variances 7 and 8 as shown on our notice, which is why the planning
no.
memo. Sorry?
Not remove number 7. Remove number 8 and modify number 7 to
Okay.
28 meters.
Modify
Sorry,
it to?
I need you to be clear. What are you changing number 7 to? What is the
Uh,
percentage and square meters?
So it'll be the square meters of 28 square meters.
0.8?
No, 28, 28.
28 square meters. And
Correct.
expressed as a percentage?
I'll hit about 31%.
31 will be provided?
Correct.
So where it said no rear yard landscaping, it should be changed to 28 square meters equal to 28%?
31%.
31. Okay,
Yeah,
so
31.
Okay, so eliminate 8, modify 7. We still got to hear from you because planning is still saying this application should be refused because fourplexes are not permitted in this zone.
Correct.
So okay, let's starting off. You've modified and you've eliminated variances 8. That's wonderful. So now let's hear a presentation of why this is worthy of consent as a fourplex where a fourplex is not permitted.
Okay, so Brown's Line is a very unique strip. It's a main road.
Sir, it sounds like you're putting like a sock over the phone. Are you talking on a speaker or are you too close to the phone?
I'm talking right into my computer.
Okay, that's better.
Okay. So Brown's Line is considered a main street. It has a lot of different types of uses on this street. It has multi-rental residential. It has commercial. It has single-family dwellings, and this particular lot is zoned U3. So I'm permitted as of right to put 3 units on this lot. So I don't find it major. I find it minor in nature. I'm just asking to add 1 single unit to my already permitted 3-unit dwelling. These will be rental units that I will build and I will keep for myself. But the street mix, it has condominiums, it has apartment buildings, it has commercial units, it has single-family dwellings, and it has rental units. So I don't think I'm going against the grain here. Like it is served by both GO Station and TPC, and I find it like not major at all. What I'm proposing. The other variances that stem from it is basically because of the fourplex. Now let me tell you something. Even if I go as of right and I put my 3 units, I will still have number 5 as a variance. I will still have number 2 as a variance as well. Okay. Just because.
Okay, but if you came back with a triplex and you had certain variances, well, a lot of people, that's why we have a committee of adjustment to deal with variances, or minor variances. They are saying in their memo, and you got that memo, it was written, I don't know when it was posted, July 22nd. Did you contact planning staff? Because what they're saying, this is more appropriate that it be done by a zoning bylaw amendment to introduce a building type that is currently not permitted in the bylaw. So they're just saying, they're saying you have to, you know, it's more appropriate if you wanted to try to get this, that you have to do it by way of a, not before committee of adjustment, but as a zoning bylaw amendment application. What do you say to that? You don't agree?
So I've had a very similar application to this. Like it had the same zoning. I was permitted 3 units. I brought it into committee of adjustment, and the planning staff at North York didn't have the same thing to say. So I'm saying I understand if the one planning staff on that end had the same thing to say as this one, then I understand. But I went in through committee of adjustment because I had that one approved maybe.
Okay, sir, every application, as you know, as a planner is different. There's different considerations. So the fact that you got a fourplex approved in North York somewhere, which we don't, you know, where let's say a fourplex was not permitted through committee, I'm not, you know, you do have information about that? We don't, you know, every situation is different. I don't know where that was done, whether, you know.
Yeah, I gave the planner all that information.
Yes.
I could share it with this committee if you want, but all I'm saying is the Planning Act should be throughout the board, meaning that if it applies to North York, it should apply to Etobicoke, it applies to Scarborough. So I can test them when they say this should be going through a zoning.
Sir, you're fading out again. You're fading out again with your voice. I'm trying to hear you.
Sorry. Like how I think the Planning Act should be throughout the board. I had a file, as I said, I disclosed all the address, the file number with that planner, and I said, North York planning staff didn't say I have to go through zoning bylaw amendment. And now you're saying I have to go through zoning bylaw amendment. It doesn't make any sense. If it was throughout the board.
Sir, each application is heard on its own merits, and each area of the city can have different circumstances that may warrant a different planning opinion. In this case, planning is recommending refusal. The committee is asking you whether or not you considered planning's recommendation. We're not talking about a property in North York. We're talking about this application before the committee today.
And certainly, if you wanted us to look at that other application and try to draw comparisons or to say it's all the same, you should have brought that to our attention before us today by a copy of that decision. So, you know, I appreciate what you're saying. You're saying, if I got it in North York, I should get it in Etobicoke. But even if it was another part of North York, every application, as I said earlier, and the Secretary Treasurer just says, is considered on its own merits. So if you wanted us to consider this other application, albeit it's in North York, it's not before us right now. Anyway, committee members, any further questions for the applicant? Or is someone ready to make a motion? Oh, sorry, we have another speaker on this. My apologies. We have a speaker, the neighbor at 623, Mary Borges.
Hi there, good morning.
Good morning. Sorry, I almost forgot about you.
That's all right, no worries.
Okay, so you've been following
yes,
along. So you've been following along? So
yes, I have been.
Okay, so you live.
Go ahead, I'm sorry.
Do you live next door? I don't know. I know it's 615 to 623.
Yes, we do.
It's
yes,
right next door.
I am right next door to this unit that wants to be built. So myself and the neighbors and this community, we would like the committee to disagree and disapprove this because allowing this fourplex to be built is setting the grounds for these builders who already are coming into our community and building on one single property, building 2-3 lots. These lots are small in a sense because, you know, the old houses that were built on it, but they're building 2-story homes much higher than back in the old days 2-story homes. So they're overpowering and overlooking into everyone's backyards already as it is. So this four complex would be setting even higher, like setting a law for these contractors to come and now build theirs even higher. There's these homes. It's just not the area for this. I'm replying to the builder that yes, Brown's Line is a main street, but the builder is not taking into consideration that he is wanting to build in the community part, which is all residential. the area that he is speaking of, that there's factories and triplexes and all that, those are just a basement and 2 stories that are rented out, is on Horner towards the lake. So towards going south, Horner downward. Yes, there is a building being built there. I believe it's only 5 stories high. It is going to be for apartments, but that is being built in the old factory area. Where he is proposing is in a community area. These are all small homes. These are just like 2-story old century homes that we don't want this big story building coming in.
Okay, thank you, Ms. Borges. And can I ask you a question? I said, are you talking into a phone or into your computer? Because you're as clear as a bell. And, you know, just for people watching on YouTube, we're sitting here doing these applications. And when you have to strain to hear what someone's saying, it makes it more difficult. But you were very, very clear. So makes it easier.
Thank you so much. I am speaking to my phone.
Okay. Thank you. So perhaps when other people have difficulty speaking into their computer, we can ask them to switch to talk on their phone, because it's important that everyone be heard. So we've heard your concerns. Thank you for that. Let's see if we'll have to now give the applicant an opportunity to respond to what you've had to say, and then we're going to take it into committee for a decision. So please stay on the line. Okay.
Hello?
Yes, Mr. Scone, please respond. And I think to the neighbors, she's pointed out that although you said in your remarks that there's condos and there's all kinds of different built forms being built, it's on a different part of Brown's Line. Is she correct?
Okay. No, like just to the north of me, there's 2 apartment buildings, maybe a block and a half north. Right where the Brown's Line goes into, I guess, the merging of the highways. It's a block and a half north of me. Right across the street from me, there's commercial establishments. And my lot's not a single family residential zone. It's a youth zone. I'm committed to 3 units. So also, as for the height of overlooking, I don't have a variance for height. I kept it within the height range. As for the length, I kept it within the length range. As for the size of the wall, I kept it within the size required. So I don't understand the overlooking part, because that will not happen.
Again, you're breaking up, sir. Having trouble. You don't understand. What don't you understand?
I don't understand how she's gonna have an on-look issue when I'm not affecting height.
Okay,
I'm within the height requirement and my length and my total size of the dwelling.
Okay, but there's the variances, but there's also the factor that the RM designation for the site doesn't allow for this built form. So when it doesn't allow for it, it's not a question of saying whether what you're proposing is minor or major, or minor or not major. It's an issue, but it's not permitted, and that's why a more complete zoning bylaw amendment, which is they do a more in-depth review than we can do here at committee, they feel is more appropriate to introduce this building type be made by way of that, not as opposed to dealing it through the minor variance. Okay.
Also, how I was looking at it as well, I do have the larger lot. I think I have the 50-foot lot. I think there's maybe 1 or 2 left 50-foot on that street. So even if I would bring forward an application to subdivide the lot, and I am successful, now I'll have 2 units, which I could commit 3 units in each. So now that's 6 units compared to 4. So I think how I'm doing it now is more respectful than if I just subdivide the lot or try to subdivide the lot.
You're gonna try for sure. Okay, anyway, that's not really an answer to say what else you could do. If you want to do something else, you can do something else.
Well,
we have to deal with what's before us right now. So
I don't mind going down 3 units. It will change other variances. Like number 5 would go down, or sorry, number 5 would go down to required side yard setback to 1.8 meters, and the two would
Sir,
count
this
as
is not a negotiation. You have your application, you submitted it to committee. You're
No
in
problem.
rebuttal now, so the committee is making a decision on the current
You're giving us
application,
more
which is for a
information, so-
fourplex.
Yeah. Okay, so
Okay,
we're going
no
to take it
problem.
into committee now because, sir, you're giving us more information and sort of opining as to what else you could do that would be worse than what you have before us. That's not responding to Ms. Borges' issues. So we're going to take it into committee. Laura, I believe Ms. Alderson may have a question for you.
Actually, I don't have a question. I'm actually ready for a motion, but if anyone else
Okay.
has a question, please go ahead.
Right. Anyone else have a question, or else we have a motion?
Well, just a question for the applicant. Did you not consider submitting a zoning amendment application with a planning justification report and any other studies that are required with a zoning amendment?
Due to the length of process with the zoning amendment, just to add additional units, I don't think it's worth going down that road. It's way too lengthy for one additional unit. And again, we never had this concern from other planning.
Okay, Ms. Alderson, you ready to make a motion?
You know, with all due respect to the applicant, this is a change of use. Therefore, it's not minor in nature. That's fundamentally the case. So I'm afraid I'm going to make a motion to refuse this application. Community planning wants it refused, and I have to agree with them.
Thank you. Seconder for that motion. Mr. Kamarick, discussion, all in favor? The application has been unanimously refused. Thank you, Ms. Borges. Thank you, Mr. Ciccone. And Mr. Ciccone, next time you have occasion to call in, I suggest perhaps you maybe talk on the phone. I'm going to suggest that to more people because it makes it really difficult. It's, we want to hear what everyone has to say, and a little bit muffled, but we were able to get through. Thank you.
Thank you. Okay,
okay, our next applicant, we have two more applications for the morning session, which are numbers 11 and 12. So number 11, 90 Edenbridge Drive. It's an application, construct 4 one-story additions along the north, east, south, and west sides of the existing dwelling. We have advisory comments from Ravines. And then they said they're okay with the new plans. And I believe that's all we have. Registered to speak is Ian McLaren and James Kelly, who is the owner. So we don't have anyone in opposition. We just have the agent and the owner available to answer questions. So welcome. Mr. McLaren.
Thank you very much.
Very straightforward application. You're aware of the... you've been dealing with Ravines, I take it?
Ravines has no objections, and TRCA is in support of the application.
Correct. So unless there's anything you'd like to add, I don't think we need a fulsome presentation on this from you. Just let's see if committee members have any questions or if someone's ready to make a motion.
Perfect. Thank you, Chair.
Thank you.
Laura, you're muted.
Just a quick question about the TRCA. I understand they're now fine with the application, but they do need or do require a permit still. Is that correct?
That's right. Yeah. So they have they've indicated support of the application, but they await the committee's ruling before they'll issue that permit.
Right. So
and you're aware of the urban forestry planting plan requirements?
Yep, we've had
urban forestry
good discussions with them too.
Was there an urban forestry on this application? I didn't see that.
They have requirements. I'm not sure of their conditions, but they have asked for specific requirements. Planting 2 new trees, I think.
Yeah.
Okay.
And the arborist has been in discussion with them. Yeah.
Okay, but there's nothing indicated as a condition on our approval.
Correct.
I don't believe so. If you're working with it, wasn't on, didn't show up on our list as a condition. Okay, so Ravines is okay, and we're working with Ravines, so. And we have 5 letters of support on this. Okay. Any questions for Mr. McLaren? Or are we ready for a motion? Yeah, you've given us a neighborhood map and photos and shown us where the other approvals at the COA in the area, which has been very helpful with accompanying pictures.
So we don't need to tie the tree planting to the approval. Okay. So I'd like to, I find the application to be minor and meeting the 4 tests. I would therefore like to move approval without conditions.
Thank you. Seconder for that? Okay, Ms. Alderson? And all in favor? Thank you. You have your approval. And I was just talking about some neighborhood map that would refer to the next application, actually. So good segue. I thanked Mr. McLaren for providing us this map. He probably didn't know what I was talking about because it's on the next application, not on this one. But
Thank
you
you, Chair and members.
anyway. Okay, thank you. So item number 12 is our last application of the morning session until we reconvene at 1 p.m. to deal with the afternoon matters. It's an application for a new detached dwelling with an attached garage. We have 3 variances. Planning is giving us a memo where they're requesting that the FSI be reduced from 0.7 to 0.67. We'll hear from Mr. Rubinoff on that. And then Mr. Rubinoff is the only registered speaker on this. We don't have any other conditions. I don't see any urban forestry on this one. So, Mr. Rubinoff.
Hi, good morning. Yes.
Good morning, sir.
Good morning. You mentioned the map previously for your last case.
Yes.
And that's for this.
Yeah, I have to thank you now. So it's not Mr. McLaren, it's you I have to thank for this map and neighborhood photos showing exactly other builds in the area that have been approved by committee, shown in blue. And there's a lot of them.
So we also submitted 5 letters of support from neighbors. 60, 55, 58, 57, and 68. But we did have a meeting with city planning, and we did agree to reduce the density to 67% as per their request. Okay. So that's all. I don't really have more else to say.
Okay, so you are, I see the memo's dated August 20th. So that's, and the plans already reflect that, I take it.
Yes, that's correct.
Okay.
Yeah, there was no other comments.
So we do know what we need to know the gross floor area for that to plug in with the variance number 2, the revised at 0.67. How many square meters is that, sir?
Give me 1 second. Sorry, let me just grab my. Okay.
Yes.
Okay, so yeah, the 5.
So it'll be 150 meters squared plus a certain percentage, not 41. And then they need the number of the percentage from 41, or between 20, it was 25 required, you're at 41, so it'll be a little less than that, and also the square meters.
Okay, so I have the, for the 67%, the square meters is 349.69 square meters. That's for the 67. I know the other variance is plus 150. I lost the first page. Here we go. Okay, so the other one is 150 plus, so 47, it's gone to 38.
38%. 38%, which results in 349.69.
That's correct.
Okay. And that's, yeah, you have did your homework, you have all these support letters, and you gave us that context map. Committee members, are any further questions for Mr. Rubinoff, or are we ready for a motion? Variance 2. Yeah. So it should now read 150 square meters plus. Yeah.
38.
Yeah. 67, and it's 349.69.
Sorry, I have a question of staff. Can they just confirm that calculation is correct?
Who's going to confirm? Well,
So Glenn,
yeah.
variance number 2 will now state the new dwelling, including the attached garage, will have a gross floor area of 150 square meters plus 38% of the lot area, 349.69 square meters, and will have a floor space index of 0.67 times the area of the lot, in brackets, 349.69 square meters.
Yes. Okay.
Thank you very much.
Yeah, we haven't verified that's correct. Looks about right, but whenever in this situation we're revising it on the fly like that, we ask the applicant to give us those numbers, and they're not. We don't verify them, but
Mr. Rubinoff has provided them to us, so he knows that if he can't get a building permit, he'll have to come back.
Yeah.
Yeah.
And there were no conditions.
No, I'll move for approval of the variance 1, revised variance 2, and variance 3. They meet the 4 tests of the Planning Act and are minor.
Okay, thank you, Mr. Palmer. Seconded for that motion, Ms. Alderson. All in favor? Unanimous approval. Thank you, Mr. Rubinoff. Have a great afternoon.
Okay, so we're adjourned now until 1 p.m. for the afternoon time slot.
Yeah. 7, 8, 9.